Welcome back. Tim, so what is the process of appealing so our viewers understand, and what would you say is considered to be reasonable?
So when you file a tax return, that begins the process of the processing process, if you will. So you send your tax return to the government. They will process it, and they will send you what's called a notice of assessment. That's basically a letter, or now it's electronic usually. This an email that simply says, "We received your tax return. We've processed it." At that point in time, they may actually ask for more information, but usually not at that point. Usually within a month or two or three, you might get another letter from them. If they have any questions or concerns about your tax filings, they may, for example, ask to see copies of donation receipts or medical expenses, because after all, most people are filing electronically now, so they're not sending that paperwork in. So that's not what we call an audit. That's just simply a review, and it's a request for information. Nothing wrong with that. But where it becomes problematic is where you do provide legitimate information to CRA to substantiate or prove your deductions or credits or whatever you're claiming, and then they deny them. If they deny them, you have the next step in the process is to get on a phone call and have a conversation with them, see if you can resolve it by phone, which you probably won't be able to. And so what you'll end up having to do most likely is file what's called a notice of objection. A notice of objection basically says, okay, I sent in my return, CRA reassessed me, they didn't like certain things, now I'm objecting. You file a notice of objection. If you get to that stage, I would highly recommend that you call a tax professional, a CPA or a lawyer that specializes in tax, because your notice of objection should be prepared at a very, taking into account things like tax law references and court cases and things like that, just to make sure you've covered your rationale. Why are you claiming this deduction? So anyway, you've got to file a notice of objection. The problem with that is, of course, now you have to wait probably anywhere from 6 months to 2 years here. And quite often it's well over a year. And what some people will do is they'll file a notice of objection. And if it goes on long enough and you still don't hear back from them, or if you don't like their answer to your notice of objection, you have one other approach. And that is you can file what's called a notice of appeal. Now that is a request to go to court. So unfortunately, it may cost you money in terms of legal fees. Some smaller cases, if it's under about $15,000 of taxes payable, that's what you're talking about, you can represent yourself at court. That's called the informal procedure. But if it's a higher dollar amount, you're going to need a lawyer to represent you. That's where it starts getting really costly. Yeah. And my concern, Saijal, is that what's happening is, in many cases now, CRA is just simply denying expenses, even though evidence has been provided, proof's been provided. They're denying these things too often and forcing taxpayers to have to file a notice of appeal. And that gets to be costly, where a lot of people just say, you know what, it's not worth fighting it.
Yeah.
Not going to pay the cost. And so they abandon the idea of fighting it, and CRA keeps the tax. And that's just not a right approach it's not an unethical approach to reassessing taxpayers.
No, exactly, because you're putting a lot of burden on the individual who probably is not in the position to fight it. Tim, what would you like to see? What do you think would help the problem? Is it training? Is it, consistency? What is it?
I think CRA needs to give probably better training to some of their frontline people, and give some of those frontline people or people closer to the front line who are dealing with taxpayers day to day, give them more authority to make some decisions based on reasonableness. So, we want CRA to be reasonable. And, if they're going to insist on objecting or denying everything, that's going to just continually be a more expensive way for taxpayers to live. And It's not right. So it used to be that you could reason or have discussions with the frontline people, and they had the authority to allow or deny your expenses. And it seems like now they're not given that authority. They're just told to blanket deny and let people file objections and appeals, where more senior people at CRA will look at them.
Yeah. We only have 45 seconds. I did note that someone commented on your Globe and Mail article that there used to be a time when you could speak to someone actually in person. And I think that's important, right? Because it gives context. You have that face-to-face interaction. That doesn't happen as much anymore, does it?
Well, it certainly doesn't happen face-to-face, except in very rare situations where you're, in a big battle with CRA and you're being audited. But if you're just, addressing a request for information, you can get people on the phone and have a conversation that way, but you won't see them face to face. But I still think that's probably okay, just having the phone call. You just want them to be reasonable with the response they provide.